Every single day, millions of workers across America show up to jobs where they have no idea what rights they actually have. And their employers? Sometimes they don't know either. That ignorance costs people their livelihoods, their dignity, and billions of dollars in lawsuits every year. Today, we're going to fix that. Welcome back. In this video, you're going to learn the 5 most important concepts from employment and labor law. We're talking about how the employer-employee relationship actually works, what federal laws protect workers, how unions operate, what counts as workplace discrimination, and what happens when things go wrong. Whether you're a business owner, a manager, or someone who just started a new job, this information directly affects your life. Let's get into it. Section 1. The employment relationship. Here's something most people don't realize. Not everyone who works for a company is legally considered an employee. That distinction matters enormously, and getting it wrong can land a business in serious legal trouble. The law recognizes 2 main categories. You have employees, and you have independent contractors. An employee works under the direct control of an employer. The employer sets the hours, provides the tools, directs the work, and pays taxes on that person's behalf. An independent contractor, on the other hand, operates with more freedom. They control how they do their work, often supply their own equipment, and handle their own taxes. Why does this matter? Because employees get legal protections that independent contractors typically don't. Things like minimum wage guarantees, overtime pay, workers' compensation, and unemployment benefits. Companies sometimes try to classify workers as independent contractors to avoid those costs. Courts look at the actual working relationship, not just what a contract says, to determine who's really an employee. There's also a concept called at-will employment. In most of the United States, either the employer or the employee can end the working relationship at any time, for almost any reason or for no reason at all. Sounds harsh, right? But there are important exceptions. An employer cannot fire someone for an illegal reason, like discrimination or retaliation for reporting safety violations. So now you understand the foundation of the employment relationship. But what specific federal laws were created to protect workers inside that relationship? That's where it gets really interesting. Section 2. Key federal employment laws. Congress didn't just sit back and let employers do whatever they wanted. Over the decades, lawmakers passed major legislation that set the ground rules for every American workplace. The Fair Labor Standards Act, or FLSA, is one of the biggest ones. Passed in 1938, it established the federal minimum wage, required overtime pay at 1.5 times the regular rate for hours worked beyond 40 in a week, and set rules limiting child labor. If you've ever received a paycheck with overtime on it, you have the FLSA to thank. The Occupational Safety and Health Act created OSHA, which requires employers to provide a workplace free from recognized hazards that could cause serious harm or death. Employers must follow safety standards, keep injury records, and allow inspections. Employees have the right to report unsafe conditions without fear of punishment. The Family and Medical Leave Act, known as FMLA, allows eligible employees at larger companies to take up to 12 weeks of unpaid, job-protected leave per year for things like the birth of a child, a serious health condition, or caring for a family member. The key word there is job-protected. Your position has to be waiting for you when you come back. These laws set a baseline. But what about when workers want more power as a group? That's where labor law enters the picture, and it's a whole different world. Section 3. Labor law and unions. Labor law governs the relationship between employers and organized groups of workers. The centerpiece of this area is the National Labor Relations Act, passed in 1935. It gives most private sector employees the right to organize, form unions, bargain collectively, and engage in protected group activities. When workers form a union, they gain the ability to negotiate as one voice instead of individual voices. This is called collective bargaining. The union and employer sit across the table and negotiate wages, hours, benefits, and working conditions. If they reach an agreement, it becomes a binding contract called a collective bargaining agreement. The National Labor Relations Board, or NLRB, is the federal agency that oversees this process. They conduct union elections and investigate unfair labor practices. Employers cannot legally fire workers for union activity, spy on union meetings, or threaten employees for organizing. Doing so is an unfair labor practice, and the consequences can be serious. Strikes are another tool workers use when negotiations break down. A strike is when employees collectively stop working to put economic pressure on the employer. There are different types, each with different legal protections. Understanding where those lines are is critical for both sides. Now that we understand organized labor, let's talk about one of the most consequential areas of employment law for everyday workers: discrimination. Section 4. Workplace discrimination. Title VII of the Civil Rights Act of 1964 is arguably one of the most important employment laws ever passed. It prohibits employers from discriminating against employees or job applicants based on race, color, religion, sex, or national origin. Since then, additional laws have expanded those protections to include age, disability, pregnancy, and more. Discrimination doesn't always look obvious. There are two main types. Disparate treatment is intentional discrimination, where an employer treats someone differently because of a protected characteristic. Disparate impact is when a policy that seems neutral on the surface ends up disproportionately affecting a protected group. Sexual harassment is a form of sex discrimination under Title VII. It comes in two forms. Quid pro quo harassment is when someone in power offers work benefits in exchange for sexual favors, or threatens consequences for refusing. Hostile work environment harassment involves conduct so severe or pervasive that it creates an abusive atmosphere. The Equal Employment Opportunity Commission, or EEOC, is the federal agency that enforces these anti-discrimination laws. Employees who believe they've been discriminated against typically must file a charge with the EEOC before they can sue in federal court. Knowing your rights here matters deeply, but what actually happens when someone takes legal action? Let's close with that. Section 5. Remedies and employer responsibilities. When employment laws are violated, the legal system offers remedies. These can include back pay for lost wages, reinstatement to a former position, compensatory damages for emotional distress, and, in cases of intentional discrimination, punitive damages meant to punish the employer and deter future violations. Smart employers don't wait for lawsuits to happen. They put policies in place, train managers regularly, document performance issues fairly, and create clear channels for employees to report problems. Having an employee handbook that outlines expectations and grievance procedures can be a company's first line of defense. Employees who report illegal activity are called whistleblowers, and many laws protect them from retaliation. If you report a safety violation or financial fraud and your employer punishes you for it, that's illegal. Employment and labor law exists because the workplace is where people spend enormous amounts of their lives. These protections aren't just legal technicalities. They represent real standards of dignity and fairness that took generations to build. And there you have it. 5 essential concepts from employment and labor law: the employment relationship, federal protections, labor unions, workplace discrimination, and legal remedies. This is the framework that governs every job in America. If you found this helpful, hit that like button and subscribe so you don't miss our next business law breakdown. And drop a comment below with a question about your own workplace situation. I read every single one. See you in the next video.